Yeah, of course.
Good evening, a warm welcome to all of you to the webinar series hosted by Advocates Association Bengaluru. We have with us today Mrs. V. Mohana, Senior Advocate, Supreme Court of India. Ma'am, it's a privilege to have you with us. Welcome to the webinar. Now, I take immense pleasure in introducing our today's speaker. Mrs. V. Mohana graduated from the Government Law College, Coimbatore, from first batch of 5 years law course in 1988. She's a first generation lawyer and started her initial practice as a junior advocate under the guidance of her guru, Mr. Panchapakesan, senior advocate in Coimbatore, who used to practice on civil side in the district courts of Coimbatore. In 1992, Mrs. Mohana shifted her practice to the Honorable Supreme Court of India and joined the office of Justice Indu Malhotra, who was then a practicing advocate. She also worked with Mr. C.S. Vaidyanathan, senior advocate, till 1996. She also worked as a freelance editor of Supreme Court Reports, which was the only approved journal then. Mrs. Mohana cleared the Advocate on Record exam in 1996 and started her independent practice. Over a period of 24 years of practice as an advocate on record, she has argued several civil matters, criminal appeals, and parallelly appeared before the Honorable Delhi High Court and National Consumer Commission and several other tribunals. She has appeared as a standing counsel representing various central agencies and appeared on behalf of Government of India. She has assisted the court as an amicus in several landmark cases. She was designated as a senior advocate by the Supreme Court of India in the year 2015. During her free time, she reads biographies of various legal luminaries and enjoys Carnatic music. Ma'am, on behalf of Advocates Association Bengaluru, I extend a warm welcome to you. Over to you, ma'am.
Thank you for the generous introduction, Mr. Trivikram. I'm very honored to be here today. I'm thankful for this opportunity to share my knowledge, a little bit of whatever I got to learn in the past and also in the past few days after accepting this from you and from my senior while practicing and from Justice C.K. Tucker's CPC. What has interested me most is the practice in the trial court. So I have taken a love for CPC from the beginning, though now I am practicing in the criminal side as well. Thank you very much, and without any delay, and I want to thank all the participants for spending their evening on a Friday here, which is especially our Lakshmi Day Puja day-to-day evening will be a lot of commitments, but in spite of all that, showing your enthusiasm for a lecture like this shows your commitment, and I try to put a little bit of my whatever I've learned. I hope it will be somewhat useful for this day at least. So today I have chosen the topic of first appeal, revision, review under the CPC. Actually, there is second appeal also. We said appeals in general. If time permits, we can cover all of them exhaustively, but for the time being, let me just address whatever I can in this given slot of time. Let me first take you all to the first appeal. Unlike civil suits, first appeal is not an inherent right. It is actually in suit means anybody can file a civil suit unless it is expressly barred by any legislation. But appeal is a statutory right. Of course, it's a substantive right, not a procedural right, but it has to be provided by the statute. So, and it's a vested right because as soon as you file a litigation, then on that day itself, your right to file an appeal, if it is already there, that vested right continues. It can't be taken away unless by way of an amendment. Now, the difference between an appeal and a revision is that appeal is some complete rehearing and a redetermination, whereas revision will only consider an exercise of jurisdiction, whether it is erroneous or with material irregularity or failure of that is in exercise of jurisdiction. I'll come to a greater detail about that. When you go, the first appeal is governed in CPC by section 96 and order 41. Section 96 to 99 cover first appeals. 96 talks about who can file an appeal. For filing an appeal, first you have to satisfy twin conditions. One is it should be a final decree, finally a decree which determines the right of parties. And secondly, you should be adversely affected to file an appeal. What is meant by adversely affected, in fact, has been defined and explained in a very interesting judgment of Adi Firoz Shah versus H.M. Sirwai, in which it was said an appeal cannot be filed by an advocate general against an order passed by the Bar Council. In this case, what happened was an action was initiated against an advocate for a misconduct allegedly committed in London. So a suo motu cognizance was taken and Bar Council Maharashtra issued a notice and it was found to be. And later on, after his explanation was accepted, it was dropped. But the Advocate General filed an appeal, which was allowed. So this matter was carried to the Supreme Court, and the Supreme Court said that an Advocate General cannot be an aggrieved person in the sense that he can file an appeal, that he is aggrieved by this. In fact, it was a bench of 5 judges. 3 of them, the majority view is that the Advocate General could not have filed the appeal, but the minority view held it is actually affecting the rights of the public interest, so therefore the Advocate General could have filed. But ultimately, what has been discussed is very important for us, is who is an aggrieved person, who can file an appeal is very elaborately discussed. I will give all the citations that I will be referring to in the course to Trivikram. Later on, you can take it. I'll send him a list of all the cases. So this is to begin with. One has to be adversely affected. So for example, but you can sometimes, there may be a sale of property. So therefore, a legal representative can file an, provided he has been impeded, he can file an appeal. In case of minors, guardians can file appeals. And in case of transfer of rights or any other persons with the leave of court can file appeals. So these are various persons and categories who can file first appeals. Even against an ex parte decree, an appeal lies. Of course, there are cases to say that when you file after an ex parte decree, you move an application under Order 9, Rule 13 to set aside a decree. Even after dismissal of that, an appeal lies. The court cannot say that the time has been wasted in pursuing Order 9, Rule 13. So therefore, there is a delay in filing the appeal. It will be examined according to the facts and circumstances of each case. And therefore, in recent judgment, Justice Bhanumati, in 2 of her own judgments, have held that merely because a party has been pursuing an application to set aside an ex parte decree would not mean that the delay in filing an appeal against the ex parte decree cannot be condoned. There are certain cases where the parties deliberately delay it by taking time after time. So those records will have to be examined to find out whether an appeal is maintainable. But effectively, what it says is under 96(2) also an ex parte decree can be appealed. But this is the law is that even assuming you have moved an application to set aside an ex parte decree, you can still file an appeal thereafter. And of course, against a consent decree, there can be no appeal that can be filed. And of course, the section says in petty cases where it involves only up to 10,000, unless there is a substantial question, there is no appeal beyond 10, up to the level of 10,000 rupees. And as per section 97, what we know is that when there are some suits like partition suits, mortgage suits, etc., where there are 2 decrees. One is a preliminary decree, another is a final decree. There are some questions which ought to be agitated even at the time of preliminary decree. If you don't agitate it at the time of preliminary decree, then you cannot agitate those questions while you are challenging the final decree. So those are certain basic aspects in the first appeal. Of course, there are these section 96, 97 and 107 spells out what are the powers of the appellate court that has to be read. These are all substantive provisions. They are read with Order 41. Order 41 is an exhaustive procedure by which an appeal is filed, whether an appeal can be decided ex parte, whether an appeal can be dismissed for default, what kind of orders can be passed, what are the powers of appellate court. I will detail some interesting propositions under Order 41 first, because all of us who are present here, mostly in the civil side, wherever if we are practicing, you would have come across orders which has to be appealed, orders which have to be challenged in revision, or we have to approach the High Court in second appeal, either first appeal or second appeal at some stance, or we have to file appeal against orders which are passed in civil suits which are appealable. So therefore, let us know what are these powers of the appellate court which are provided under Order 41. First is you can't raise any new ground. When you are filing an appeal, you have to set out all the grounds in the memoranda and you can only argue those appeal grounds. Of course, the court can look into any other grounds which have not been spelled out on its own, but no new grounds can be agitated in an appeal. However, there are certain exceptions and Supreme Court in a series of cases have held new grounds if they are absolutely legal grounds for which factual foundations have been laid can be agitated in the first appeal as well. In fact, there are cases where the appeal grounds, the new grounds have been agitated even during the arguments in the appeals, and the courts have considered. The Supreme Court in these cases have held that it can be actually entertained, and therefore there are some cases which are very classic. Let me see. There is a case where, while arguing in a case of possession and mean profits, the High Court had ordered calculation of mean profits for 3 years, calculation of mean profits without mentioning anything. After calculation, the respondent, the judgment debtor approached the court by raising an amendment saying that mean profits cannot be calculated beyond 3 years after the decree, especially when the possession has been already delivered. So that was rejected, but the Supreme Court held, even assuming the ground was not raised earlier, this is a ground for which you don't have to lay a factual foundation, because the law under Order 20, Rule 12 is also the same. So therefore, since this is a purely legal issue which could have been determined without any leading in further evidence or even putting the other party into prejudice, and this is the legal correct position, so it was entertained. So likewise, there are certain new grounds which have been permitted. In the most recent case of Lubina, in a rent control matter, Justice Cowell and Justice Joseph's judgment, in that what they have held is that it's very interesting. In that case, a rent control petition, eviction was filed on 3 grounds: bona fide user, willful default, and subletting. There were 3 portions, and the notice was one notice and the petition was one composite petition. In that, up to the High Court level, the landlord was found to be entitled for only one portion. It has been found consistently that one portion has been sublet by the tenant. So when it reached the Supreme Court, when the matter was just about to be heard in the beginning, additional grounds were raised and it was permitted by the Supreme Court, that additional grounds stating that a lease is composite and therefore subletting of one portion will entail the eviction of the entire premises, and this is a legal ground. So that was permitted. Even thereafter, the tenant had not filed any cross objections as far as the other portion of the decree was concerned, that is about the one portion, or nor did he file any objection to this additional grounds application. Leave was granted, and ultimately when the appeal was allowed on this very ground, the entire appeal was allowed, stating that this is a ground which is substantial, and it is in law it is correct that if this is the one portion has to be sublet by the tenant, which is actually a composite lease, then the eviction entails the entire premises. Here there is a complete discussion of what happens and what stage a new ground can be permitted, and this is also a legal ground. And second point was, the tenant never raised an objection when the additional grounds were raised. So these were important considerations before the Supreme Court. So therefore, we have to keep that in mind when we raise additional grounds before a first appellate court or anywhere. We have to remember that unless there is a factual background laid for this, like in a case where there was a claim by a HUDA, a housing authority, for payment of amount, the lady never deposited, the applicant before the Supreme Court never deposited the amount, and she said that she could not deposit the amount in time. She approached the court after 7 years for the allotment, but the HUDA said that it is not correct, that she has not deposited the money. They succeeded, but in High Court, when she approached the High Court, she raised a new ground by saying in the argument, stating that she has not received the allotment letter at all, which was allowed by the High Court, but that was set aside by this Supreme Court, saying that you cannot raise any new grounds for which there is no foundation laid in your arguments or in the pleading or somewhere else, so that without much of an examination or without causing prejudice to the other side, that it can be examined. Complete questions of law can still be allowed. That's one. And thereafter, then we move on to the Rule 4 of Order 41 says, when you can file a case, when there are more than one plaintiff or more than one appellant or respondents, a common appeal can be filed on behalf of everybody. This is an exception to the point that only for those who file an appeal, the relief can be given. Very interestingly, there was a case where 9 landlords file case for eviction of two people. One is a tenant, the other was a subtenant. It was decreed, and the subtenant filed an appeal. During the pendency of the appeal, one of the landlords passed away. When the landlord passed away, that there was no application for setting aside, the impediment of LRs. And when the final hearing reached, this objection was taken by the tenant that one of the appeals have abated. So therefore, the entire appeals cannot be proceeded with because all the owners should be there and the right to sue does not survive. The argument put forth before the court by the landlords were that one is that we are all co-owners, so we can take refuge under Order 41 Rule 4, which says one of the parties can file appeal on behalf of all of them. This was rejected, saying that since you filed 9 different appeals against the eviction, against the non-grant of eviction, so this is not a case which is covered under Order 41 Rule 4. So this is an exception. It says that when you have filed the case individually, you cannot then go back to say that we are all having a common interest. Second argument was we are all from a joint family, so one person can file an appeal for all of them. That also was rejected because it was never found, and even the pleadings of the landlord themselves is that they are not joint owners, they are not in a joint family. That is why precisely the cases were filed dividedly. So therefore, this was not entertained. So they shifted their argument to Order 41 Rule 33 to say that an appellate court can pass any order to meet the ends of justice. But the court said that 33 can be applicable only when there is a legality in the order, and to effectuate that legality, you can give effect to Order 41 Rule 33. So this was not a case where Order 41 Rule 4 or Order 41 Rule 33 can be applied. This I thought was very interesting. This is a case of 1964. I'll give a citation. This is called Rameshwar versus Shambhihari. Now, only to give uniformity in decision and full power to do justice to all parties, Rule 4, that it gives that any party can file this on behalf of all of them. Now, Rule 9, 10, furnishing security, delay, continuation are all procedure. Order 41 Rule 5 says that merely because you file a first appeal, there is no automatic stay. Just somebody is being asked to vacate and hand over possession, you file an appeal. You cannot sit tight saying that an appeal has been filed, so there is an order of stay. There is no such rule like that. Rule 5 has 2 provisions in which one, either the appellate court can on your application pass an order of stay, or the court which passed the decree, if the appeal time is not over and no appeal has been filed, the court which passed the decree can also stay the operation of the decree, provided there are 3 conditions which are given in Order 41, which is that it shows there will be a substantial injustice and that you have approached the court without any delay or any other grounds that the court may think fit. Only then that it can be granted. That's about an interim stay when you file an appeal. An appeal can be summarily dismissed also if the appellate court on the first day of itself finds that there is no case, and it can transpose a party, add a party, amend everything. Lot of powers are there. Now I'm coming to another interesting provision in Order 41, which we all can use at some time, is that Order 41 Rule 22. 22 is an excellent aid to the parties without filing. Suppose there is a, for example, there is a land acquisition or a motor vehicles appeals, or there are many cases, or even in a rent control matter. Like, I'm only taking it as an example. An order has been passed which is partially in the favor of the petitioner and partially in favor of the respondent, in which event one person would have filed an appeal. If both of them appeal against the aggrieved portion of the decree, that is called a cross appeal. An appeal and a cross appeal. A person predominantly wins, files a cross appeal when the main appeal is there. Suppose you don't file an appeal also, Order 41 Rule 22 enables the litigant to file his cross objections within a period of 1 month from the date of service of notice of final hearing issued by the High Court or the Appellate Court. Now, this came up for interpretation. There are 2-3 things. One, it also says that you can challenge it even without filing a cross objection, that a decree can be, while it is attacked, while it is supported by the respondent, it can also attack that portion which has gone against him. In that event, this Order 41 Rule 22 will come to your aid. An interesting question came before the Supreme Court about the limitation. In 2011, there was a case where a person was a caveator in a matter and he entered appearance in the first appellate court. The case was like this. He succeeded, but he entered caveat in the appellate court. When the other party appealed against that decree, he was on caveat and he came for the subsequent hearings. And later on, after 404 days, he filed a cross objection before the appellate court. The appellate court, which is the high court in that matter, dismissed it, saying that the section says, Order 41 Rule 22 says that a cross objection will have to be filed within 1 month of notice. So you have been on the first hearing notice, so there is no notice required for you, and your delay is cannot be condoned. So cross objection was not entertained. It reached the Supreme Court. It's a very beautiful and an elaborate judgment in that the Supreme Court said it is not mandatory that a cross objection will have to be filed only within 30 days, because what is essential is that you have to see that the provision very clearly says the notice of final hearing is what is important. So the 30 days will have to be seen when the notice of final hearing is given by the court. That is what the order, this 2011 6 SCC 321 by Justice Ganguly and Justice Swatantra Kumar said that a cross objections can be entertained. However, in this particular matter, they have interpreted it by saying that when a caveator is present, the scene is different. The caveator is deemed to have, he has already received notice of hearing, he has already received a final hearing notice as well, and therefore, as far as a caveator is concerned, it is deemed service and it shall commence from the date of the first appearance that he has come. But in the facts of the present case, it said that since the application for condonation of delay has not been considered properly and there is no reason why the delay should be condoned in that particular case, they've remanded it for considering the cross objections. Why I'm saying this is it's a valuable right. When somebody comes to us saying that we have to defend an appeal, a notice has come. The first thing that we will have to notice in that is that supposing the claim is being somewhere disallowed as far as we are concerned, then it is at that point of time we will have to advise the client that as far as this disallowed portion is concerned, we may object to that decree either by filing a cross objection or filing a cross appeal, or we may even first point out even without that, because there are cases where in the Supreme Court itself, in land acquisition, where the portion of 23(1)(a) was not allotted, a party has filed in the first appeal only an application in the government appeal. An application under Order 41 Rule 33 alone was filed for considering payment of this. It was disallowed, saying Order 41/22 has not been filed. That was set aside, and the Supreme Court said Order 41 Rule 33 is to prevent injustice and to do substantial justice while disposing of an appeal. And secondly, that time Paripurnan judgment was there. K.S. Paripurnan says all these benefits under the Land Acquisition Act will have to be given to the owners, and therefore on that ground the Order 41 Rule 33 had to be allowed, and therefore that was allowed by the Supreme Court. So why I'm saying a very technical reason for not challenging it can come in the way of the parties when an appeal, when a respondent brief comes to you, when a first appeal is filed. So we have to essentially see whether any portion has been disallowed as far as we are concerned, and we should protect the interest of our clients. And very recently in a judgment, the Justice Nageshwar Rao's judgment has come in a matter where they say the cross objection is not even necessary to be filed to dispute the adverse findings. It is it's in the online, it's not reported in 2019, it's State of Andhra Pradesh versus B. Ranga Reddy. In this, what had happened was there were 3 suits filed against the state government. 2 suits were dismissed by the same party. 2 suits were dismissed, 1 suit was decreed. Against the 2 suits, government did not file anything. As far as the 3rd suit was concerned, an appeal was filed. The appeal was dismissed on the ground that the findings in the other 2 suits will operate as res judicata as far as the state is concerned. Here, this reached the Supreme Court, the state approached the Supreme Court. By this judgment, it was held that it is not necessary because an appeal can be filed only by an aggrieved person. The state could not have filed appeal against the two dismissed suits, and it has filed an appeal in the third suit where it is lost. However, the state could have very well agitate its claim without filing a cross objection also. The adverse findings can be challenged as far as Order 41 Rule 22 is concerned. So therefore, the High Court was wrong in rejecting this appeal only on the ground of res judicata, because the state was very well in its limits to challenge the two suits without filing a cross objection. And this court also applied Order 41 Rule 33 to help the state and also to prevent injustice and to do substantial justice. 33 was also invoked, and this appeal, state appeal, was allowed. Generally, Motor Vehicles Act, like an insurance company files an appeal, then the claimant file a cross appeal. Land acquisition, the government gets some enhancement, then we challenge the enhancement is not enough. Like that, there are so many cases, appeals and cross appeals. Whenever it comes to us, we have to look out for these. So this is about cross objections. That is Order 41, Rule 22. Then these are all about, the one beauty about cross objection is even if the appeal is dismissed for default or for abatement or as non-maintainable, that still, I accept these three cases, even if the appeal is withdrawn, the cross objections can be heard. And the time, as I said, that it is 30 days is not, actually it's always liberally interpreted. Now, we can go to the other important provisions is that we have, whenever we approach the court, the appellate court sometimes finds only on the question of maintainability. And if that is when the trial court, suppose I file a suit and the suit is held to be not maintainable on the jurisdiction aspect itself, it's gone. Then I file an appeal. The High Court or whichever is the first appellate court finds that the maintainability issue is in my favor, then that will be remanded for adjudication as far as the other issues are concerned. That is Order 41, Rule 23. So as far as this is concerned, so there are various cases, but it has been held consistently by the Supreme Court that under Order 41, Rule 23, when the appellate court finds that the maintainability is in favor of the appellant, then it cannot go into the merits of the case and it should necessarily send it back. Otherwise, the order is not sustainable. Several challenges have come because some courts decide the merits also after deciding the maintainability in favor of the appellant. So that is one section. Now, another thing is there is another provision, that is 23A also is there. That is about any other case also. If the court thinks that it has to be remanded for retrial, it can be done. But there's another provision in Order 41 when it is done. That is about, there are cases where preliminary is about limitation. You have res judicata, you have no cause of action. Those are all preliminary points where the appellate court holds in your favor. But there are matters where in a case the court feels that there is a very important issue in which the court below has not applied its mind. In those, that is a particular issue, then will be sent to the trial court, and the trial court will be asked to adjudicate on that particular issue after giving notice to parties, and the finding will be kept in the suit record and it will be called for, and the appeal should be heard not only on those two issues but on all the issues before the appellate court. The parties will be given liberty to produce their objections as far as these two issues are also concerned. I'm saying, for example, there was a case, Gogula's case, in which the court remanded it, but when the reply came, only issues were remanded. The major difference between 23A and Rule 25 under which this is done is that a remand is an appealable order, whereas here it's not. It's just kept with the file of the appellate court and only an issue is sent back. Whereas in a 23A remand, it's an appealable order, and if you don't challenge it, it may come against you in the final order. So this is a difference, because only for recording the additional evidence under Order 41 Rule 25, the issue is sent back to the trial court. The trial court will allow the parties to lead evidence, the issue is already framed, go into the question and send the findings. In that particular case, what happened was after sending that, the appellate court only decided the additional issues which were sent and they left out the other main issues in the appeal. So that was set aside and the Supreme Court reiterated in Gogula versus Purimeti that all the issues, whenever you are remanding a particular issue for a trial court, it is only an additional point. So whatever is already in issue in the appeal should also be decided. Those are other issue about remand. So, and the next thing under Order 41, there are other provisions which we don't regularly come across. They are about more on procedure, about notice and service and what is the procedure in case of this remand and other things. Then I find another important aspect in the first appellate provisions is that, or even other courts also, second also sometimes, Order 41 Rule 27. This is about leading additional evidence in an appellate forum. Normally, additional evidence is not acceptable because the parties will be put to prejudice, and so therefore there are certain conditions that you will have to satisfy. This is dealt with in 27 Order 41. This is one: when the trial court has improperly refused to admit evidence which ought to have been admitted, then you can file. Then it could not, see, you say sometimes you are not able to obtain an evidence, a documentary evidence or a witness, sometimes in spite of due diligence, you are not able to get that evidence, then that you have to show and adequately leading evidence to that effect, that in spite of due diligence. And when the first appellate court requires any document or oral evidence for the complete adjudication or for any other cause, then Order 21 Rule 27 comes in. Order 41 Rule 27 is applied. So that the third is a very wide provision, that is when the court requires. It's been interpreted in several cases. The court feels that a judgment cannot be effectively given without getting hold of that particular evidence. In those circumstances, then additional evidence is permitted. Or we can say that there are cases, the true test is that a court will not be able to pronounce a judgment without the help of this particular evidence. That is the third clause when the first appellate court requires it, or for any sufficient cause. So, but this has never allowed any litigant to fill up the lacunae in this evidence. Like in the lower court, we are not able to lead evidence, we forgot, or by oversight we omitted to do something or produce a document which is already in existence. Then to fill up lacuna, we cannot lead evidence under this provision. If you are a provision, if you are an appellant, if you want to lead evidence, you will have to fill up all this. And if you are a respondent, you will have to look out for an explanation of all these three grounds under the Order 41 Rule 27. Unless they reply this, we cannot permit that to happen. So we will have to challenge it on these reasons. And secondly, whenever that happens, the appellate court will have to record its reasons as to why it was allowed. You know, why reasons are recorded is that we know about what weighed with the court. It operates as a check to inspire confidence by the next appellate forum or to disarm any objection, so that the higher court will know whether the discretion has been exercised properly by the appellate court. And the omission to record reasons is actually serious, but it has not resulted in setting aside the evidence only on that ground. So that will not go to that effect that the evidence itself will be disqualified. So either the next rule it says is Rule 28. It says the court can either record it itself or it can tell the trial court to record the additional evidence and send it here. So that's about this additional evidence. And let me just tell you about another important provision here is Order 41, Rule 31. There are certain various judgments in as far as just one case which is coming up time and again as far as the additional evidence is concerned. Before I finish, I wanted to tell you, there is a case called Union of India versus Ibrahimuddin. In this case, two things were decided. One, about, this is citation is 2012, 8 SCC 148, Justice Chauhan. This decided two things. One is at what stage Order 41 Rule 27 can be allowed. Secondly, at what point of time this application will be decided by the appellate court. By this judgment, what had happened was a decree for declaration was given by the trial court, and it was reversed in appeal. In the appeal, the respondent, the Ibrahimuddin, had let in evidence under Order 41, Rule 27 to fill up the lacuna, which was allowed without condition, and this was challenged. This was allowed first, and later on the appeal was also allowed. This was carried in appeal before the Supreme Court. The Supreme Court, in a very elaborate judgment, discussed Order 41, Rule 27 in a very beautiful manner and taking out all the case law in that respect. And finally, it said it is not a matter of right. The court can consider it with circumspection provided it covered under either of the prerequisite conditions incorporated in the provision as such. Like I told you, that it could not have been let in even in spite of due diligence, or is it essential for adjudication or some similar clauses. And it also said what stage it could have been allowed is that only at the time of final hearing the application for additional evidence can be considered, is what according to the court. It says you cannot decide it even before reading the evidence and coming to the final inquiry. You will not know as to whether this additional evidence is required. So you cannot dispose of this application before the final hearing, is what this judgment says. So therefore it says Order 41, Rule 27 will have to be decided only at the time of final hearing. So this has been coming time and again. So this is one judgment which I thought I'll refer to you. Then the next aspect is that Order 41, Rule 31 in the first appeal. That is, whenever a judgment is written, we'll have to look for all these things. This is a right that accrues to you when you challenge a first appeal judgment. So therefore, it's very important that we know what is recorded in a judgment. Order 41, Rule 31 says, what are the essentials of a judgment? Like before, right, this is about how the judgment is written. Before that, I will say a duty of the first appellate court also, which is actually one, is that when you, for technical reasons, you cannot reverse a judgment of the trial court for a mere technical reason. And one caution which is given by the Supreme Court for this appreciation in matters of reversing, even of course, it is not correct that every time you can't say trial court is right. There is a first appellate court only because there is an error, therefore it can be corrected in appellate forum. That is why these rights are created. But what I'm saying is that the court has been warning these first appellate courts also time and again for one thing. If your appeal will have to be decided on the basis of credibility of witnesses, there are some witnesses, the appellate court will have to decide the case only on the basis of credibility, the creditworthiness of a particular witness. In that circumstance, the appellate court will have to think twice and say, this is a witness whose demeanor has been observed by the trial judge. And after appreciation of the demeanor and the evidence on record, oral and the document, it has come to a particular conclusion. So therefore, giving weightage to that and thereafter taking into consideration, then only the first appellate court can reverse it, because the benefit of observing the demeanor of the witness, etc., is only for the trial. So there are at least Sarju Prasad's case and Radha Prasad, all these cases they want that whenever the very oft-quoted judgment, this Sarju Prasad, they say that when there is question of any credibility of witness which has been gone into, then we'll have to leave it to the decision of the wisdom of the trial judge who has observed the demeanor. That's only one caution. So while writing these judgments, there are certain essentials as far as Order 41, Rule 31 is concerned. That is, one, it should always formulate points for determination. So you have to see, like in a trial court issues are framed, you have to see whether in the first appellate judgment, points for determination are formulated, number one. Then the decision. What is the decision? Then the reasons for the decision. Then what relief you are giving. These are four essential aspects. Of course, there can be a general agreement. The first appellate court can agree with the trial court judgment, but in that you don't have to detail everything, but there is a general agreement, and touching upon that it has applied its mind should be reflected from the judgment. So in that, Girija Nandini's case 1967, 1 SCR 93 is a leading case in this, that how to write, and it is a concurrent judgment of a first appellate court, need not detail very many reasons. It can express a general agreement. So that's one on that aspect. Otherwise, there are a series of cases including Santosh Azari is a case which is decided in 2001, which is followed till now in many cases, is that this was a suit for declaration and possession and injunction, which was decreed. Possession was also granted. The defendant claimed adverse possession, which was negative. So the defendant went in appeal. So there, the appellate court said the title in favor of the plaintiff, but it said adverse possession has, the defendant has got adverse possession, so therefore it cannot be giving the relief of possession, so therefore appeal was allowed. Then the plaintiff filed a second appeal, which was dismissed. So the SLP, when in the SLP, the Supreme Court commented upon the manner in which the first appeal has been decided is very, very cryptic, and therefore this first appeal judgment did not decide the issue properly, and therefore it has resulted in substantial injustice. So therefore the matter got remanded back to the first appellate court for a decision, because Order 41, Rule 31 is a valuable right, and therefore we can agitate it whenever we get a judgment. It is for us to look up in these, whether these are complied with. Order 41, Rule 31 compliance is there. Otherwise, it's one of the main grounds under which a second appeal, if it is maintainable, or in an SLP, that we have to go and challenge all these. There are similar are these cases like cryptic orders, like in Vinod Kumar is a very, which is decided in 2015, and Siddiqui's case also, that is about a tenant's case of suit for specific performance, where a power of attorney was relied upon, which was actually admitted in cross, but it was not produced by the owner, but the court wrongly placed the burden and then dismissed the suit. So that was upheld in first appeal. Then trial court, decreed the suit. The first appeal reversed it, and the Supreme Court said this is where the High Court went wrong. So therefore, this issue ought to have been gone into, and the points had to be formulated and decided. So therefore, that's another case. Very, very recently is one of the judgments is by Justice Abdul Nazir. In Malluru Mullappa, it's again a Karnataka case where the appellant had filed a suit for specific performance. It's titled like Malluru Mallappa versus Kurvattappa and others. It's 2020 4 SCC 313. It was heard by Justice Sanjeev Khanna and Justice Nazir. So there what happened was the suit was filed for specific performance. The defendant contended that is not ready and willing. The plaintiff was not ready and willing, and also it was barred by limitation. The trial court dismissed the suit. The first appeal was also dismissed without any discussion. So the appellant challenged it in the Supreme Court. The entire case law in this aspect has been traced in this judgment. If you read this 2024 SCC by Justice Nazir, he has traced all the judgments up to now about Order 41, Rule 31, and he says that how a judgment will have to consider in a first appeal all these issues, and even assuming you are saying it's barred by limitation, you should have at least considered the case of the appellant is what it said. So it got remanded. And also it said you can't even, and there are judgments where in a maintainability will also be one of the points. The appellate court will only decide on maintainability and dismiss the appeal. So when it reaches the next level, the court above will have to know what is their issue about other, suppose the court holds and reverses the maintainability, where is the finding from the first appellate court? So Justice Lopur in a judgment says it's very unfortunate that if the finding is not recorded as far as other aspects are also concerned, then it makes the party go about again the full round of remand, again another litigation round. So therefore it is a request to all these courts that in the first appeals, please consider elaborately, because it's a complete rehearing and it's a substantive right of the parties as well. So that is, and mere quoting of passages from the trial court is not enough. And in one case, 50 pages was written only to dismiss the appeal, quoting all the case law. So that also was disapproved and then said you can't do this. So this is about first appeal. These are the important provisions as far as Order 41 is concerned. Second appeal, of course, we know that it is only under Section 100 and Order 42, that it is only on substantial questions of law. So that was in 1976, it was confined by an amendment that substantial questions of law only. But Section 103 says the High Court can decide factual aspects if it has been left out to be decided by the courts below. That is, a particular issue is not even decided. Then even a factual issue like a question of fraud, though pleaded but never decided till the end. Then it says if it's not even decided, then there is a question of second appeal available on question of fact as well. Also, a substantial question of law is wrongly understood and decided, then a factual wrong decision has come. So therefore, under section 103, even a question of fact can be decided. Otherwise, section 100 is only about substantial questions of law. Then we'll go to the aspect of review, because in second appeal there are very many cases. Even it is one of the first cases which I will mention in second appeal just before I go to the review is the Chunilal Mehtas case, which is decided in 1962, supplementary 3 SCR 549. It says what is a substantial question of law, and it concludes that construction of a title document or any document which is a foundational basis of a right of a litigant, the construction of that document is a substantial question of law. That is Chunilal. Like that, there are cases for even decision of questions of fact, but a mixed question of fact will not fall under this. A substantial question of law will have to be framed in a second appeal, and then the parties will have to be put to notice, and then only the appeal can be heard. Of course, the High Court has the right, the authority to write about frame additional issues as well, but it has to notify these additional issues to the parties, and the parties should be heard. The questions cannot be framed during the hearing and the judgment pronounced. That is, there are so many judgments that matters get remanded only on this ground that the substantial questions of law has not been framed. So another recent judgment on this topic is again by Justice Nazir in 2024 SCC 659. Dodda Narayana Reddy versus Jairam Reddy. That is, again, it says when a school leaving certificate was held to be not relied upon, when two courts have concurrently found, the High Court in second appeal reversed it, saying that it's not correct because the headmaster was not examined. So that was upset by the Supreme Court, and it has again given a full discussion about this. So that like that, it's not a second court of appeal. It's a substantial, only one substantial questions of law are raised, then a second appeal is maintained. Then if I come to the review is dealt with in section 114 and order 47. Section 114, it says that an aggrieved person from a judgment can file a review, and when the appeal is not filed, or when an appeal is available and it is not taken, or when there is no appeal at all available for that particular order, or when a small cause courts call for a reference and against that order, the reference is called, that is a reference provision, when a reference is called by a small causes court against that decision. So these are the conditions under 114, but the real substantive, the procedural aspect is order 47, which says when you comply with these, an aggrieved person can file when you discover a very new or an important matter or evidence which you could not have found earlier, then mistake or error apparent on the face of the record, or any other sufficient reasons. This any other sufficient reasons have always been interpreted to be a similar, aegis term generis, that it will have to be something similar to these above two grounds. So new and important evidence has to be proved that no person can be deprived of fruits of his decree. So the new and substantive evidence will have to be proved to be not available in spite of due diligence earlier, and it is only now it has come into force. So that is one, and it should be a conclusive evidence, and it could possibly alter the judgment if it is permitted to be raised in review. So those are the conditions. One example, a decree for conjugal rights is given. After that, you go back and realize by some record that the person with whom you are married is actually within the prohibited relationship. So the decree cannot be effectuated in any event. So this is an error, and this is something which you couldn't have found earlier. So this is one of the major grounds that you can raise it. Otherwise, it will result in gross miscarriage of justice, and also it will be against the provisions of law. So that is a ground. That's one example. But when you can say that two views are possible, then a review is not maintainable. Also, when there are two grounds in the judgment on which your case is dismissed, there are two grounds, but you have got a point in review only against one of them, then you can't succeed in filing a review. That's one. And about a subsequent event or a subsequent change in law, that therefore a decision has come after 2 days after judgment in your matter, which has attained finality, then you can't just go and file a review because the law has changed today. So therefore, there are cases where a notification or an order has not been taken into consideration. Suppose a law which has been amended, the old provision has been seen by the judgment and therefore it has resulted in error. So those are cases which are error apparent on the face of the record. In those cases, review is maintainable. See, for example, in this Rafael case, review was filed, but the records were already there, the arguments were already heard. So therefore, in that case, the Supreme Court said there is no mistake of fact or any error apparent on the face of the record. What the court has repeatedly said is that when your review can be entertained, when the point that you are agitating in the review is an error apparent, meaning that there is no need of a separate judicial determination or a lengthy proceeding to arrive at a finding. It should be there, visible, and therefore, like for example, like I told you that this is a secondary, a prohibited degree relationship, something like that. It has to be self-evident and it doesn't require any investigation or a further examination. Then only a review is maintainable. Like for example, like I told you, I mean, amended law with retrospectivity has not been taken into consideration. Yes, sometimes a notification in certain areas about limitation, a particular limitation in specified areas will be given. That notification has not been taken into consideration while deciding the case. Then again, that's an error apparent. Court decides an issue which is not even an issue between the parties, and court decides without notice to parties. Then there is a review possible. Then when there is error, there is a basic want of jurisdiction, then there is a review which is possible. Then this law is settled by Supreme Court, then the court below does not notice it and then takes a contrary view, then a review is possible. It's not for a subsequent judgment. I'm saying the law settled as on the pronouncement of the judgment on your case. So error in merits is and error in view of law. A judgment can be right, a judgment can be wrong. So every error in a judgment cannot lead to filing a review petition. So that's a subsequent change in law is no ground also for filing a review. Any other, like, for example, in one judgment, the council gave a wrong concession, which is beyond which dehoards the statutory provisions. Based on the concession on a misconception, a judgment was given. That was reviewed in a review judgment, which is MMB Catholicas versus Athanasius. This is one of the oldest case, AR 1954, Supreme Court 526. This is about a misconception of the court. This is analogous to a concession by the council. So based on that, a judgment was given. So, and again, omission to frame an issue or negligence of a party to project certain issues are all not grounds of review. And let me tell you, there is no inherent power of review. But every court, to meet the ends of justice, there are certain powers inherent in every court that can be exercised to correct any grave or palpable error. Classic case is the Central Information Commissioner's case, that is Union of India versus Namit Sharma. In that, for appointment of Central Information Commissioner's case was filed there for their direction. The Supreme Court, by a very detailed judgment, gave that the information commissioners will have to be selected by these would be the criteria for their selections and everything. After all the judgment was passed, it was pointed out in a review that the legislation as such contains certain provisions, and therefore the findings of the court are not in conformity with the provisions of law. So therefore it was reviewed and then held that it's a glaring omission, a patent mistake or a grave error can be corrected in review. And therefore, but anyway, review is not for a rehearing, but if there are such kind of errors which are blatant and error apparent on the face of the record, so it was reviewed. So that is about review jurisdiction. As far as Supreme Court is also concerned, there are certain times reviews entertained, and reviews are like recently in Kodai distilleries, the question which was decided was when an SLP is dismissed in limine and thereafter a review is filed in the High Court, what happens and whether the judgment is a merger or not. That's a separate discussion as such that I'm not getting into today, because that will take a separate session as such. Now, a very important power of the Appellate Court, the High Court, which is as well as the Appellate Court, is the revision, the revisional power of the High Court, which is under 115 of the CPC. So a revision is a very discretionary power. It's not a substantive right. It's actually, it can be either suo motu or by invoked by the parties. It's a case only in a case which is decided, when there is no appeal lies. A situation where we have order 43 rule 1, etc., where there are lots of orders in order 43 CPC, which talks about orders which are appealable. These are not judgments. In a matter, you file an injunction application. In a civil suit, an interim injunction is dismissed or an interim injunction is vacated, whatever. So those are stages where you will have to approach the court immediately, the appellate forum. Those are appeal against orders. They are order 43 rule 1, which are expressly provided. There are certain cases which is a plain rejection or a plain return, which is mentioned. There are so many substances, so many criteria as far as order 43 is concerned. But revision is dealt with by 115 alone. It says it is either suo motu or by application in any of the circumstances which are fulfilled. A high court can revise when a case is decided. It amounts to a case decided, and if it is decided in favor of the party who is approaching the revisional forum, it would have finished the case as such. It is that kind of circumstance. Then a revision can be filed. Revision means what should come in our mind is an erroneous exercise of jurisdiction. Revision is always associated with an error in jurisdiction. Either it is not exercised when it has to be exercised, failure to exercise jurisdiction, excess and exceeding its jurisdiction. Third, it is exercised with illegality or material irregularity. These are the three circumstances in which a case decided, in which there is no appeal, can be challenged in revision. We all very routinely file revisions day in and day out, but we have to point out this is falling under any of these grounds. Unless we point out this is a case decided, or that there is this is something like there is no appeal against this. Classic case is that one, this is a major Khanna versus Brigadier Dhillon case. This is a 1964 classic case which decides what is a case decided, even before the amendment which came in. There is an amendment to 115 in 2002, effective 99 actually. So in that amendment, there were two clauses in the proviso, that is about the case decided, and the other one was giving wider powers. That has been removed. Now what is remaining is only about that if it is decided in favor of the revision applicant, it will put the case to an end. So that is now the clause. But that has already been decided in Major Khanna's case. In that case, I'll just tell you, it was a case of dissolution between two partners, Khanna and Dhillon. They were doing a business, and some amounts after calculation, and they were in the joint fund, some amount was given to Khanna, and it was Dhillon had filed a suit against him for return of the money, calling it as a loan. So this was opposed, and in this an order was passed that as to maintainability was the defense. Maintainability was held in favor of the defendant, and the suit was dismissed. But sorry, the suit was not dismissed. The trial court said the suit is not maintainable, and for some reason the trial court kept it back. It didn't pass any order. This order was challenged in revision. This revision was allowed by the High Court, and it reached the Supreme Court. Khanna took it to Supreme Court, saying that the revision could not have been filed and it is not maintainable. Three judges, Justice Shah, Justice Sarkar, Justice Hidayatullah. There are two opinions. One is by Justice Shah along with Justice Sarkar, there's a majority, and Justice Hidayatullah. They say that it is the both have said, as far as this issue of case decided is concerned, that one says it is a case decided, there is an appeal maintainable because it disposes of the suit. But Justice Hidayatullah says it is a case decided because it will put an end to the suit. But the trial court acted with material irregularity in not passing the final order and keeping the suit back. So there is no question of an appeal now being filed. An appeal will be filed only when a suit is disposed of finally. So therefore, this is only an order which is passed in which a case has been substantially decided. So therefore, in that sense, it is a case decided, and therefore an appeal was, though a case is decided, an appeal is not maintainable just now. So therefore, a revision was maintainable, and therefore, if the issue was held in favor of Dhillon and the appeal was dismissed, that the High Court order was justifiable. So that is a classic case in which it has brought out what is a case decided. So therefore, in all these cases, ultimately what is to be seen is whether it is a case decided against which no appeal lies. In fact, this issue was also discussed whether an appeal was, appeal lies against this order. But the suit was kept back. So it said there was no appeal that was possible at that point of time. When the amendment was brought in, it was challenged in the case of Sivashakti. In that, they said the amendment will bring in a lot of difficulties to the High Court, because in the High Court, a lot of cases were pending on that day. The exact amendment I'll tell you is that it says only for cases decided, and only when the issue is put to rest, then the revision lies, not for any other reason. So since the amendment will be, and this is a procedural amendment, so the Supreme Court, after hearing all the parties, said in Sivashakti Industries that this is a procedural, and therefore it can't be said it will be only prospective unless it is said so like that. So therefore, this is a case which will have to apply all the pending cases as well. That is Sivashakti Cooperative Housing versus Swaraj Developers, 2003, 6 SCC 659. It said this is retrospectively applicable. So all cases before the High Court which are pending as on that date will also be affected. Now, in a case where an amendment is dismissed, they came in revision, which was dismissed. And the Supreme Court said this can't be a case decided because the amendment is not going to finish the case as such. So therefore, it cannot be equated to a case decided in which the rights of parties are finally determined. So therefore, it is correct that it's not a case decided, and the High Court rightly exercised, said that it is a revision is not entertainable in these kind of cases. That's another judgment of the Supreme Court in Prem Bakshi, which is in 2002. They said an amendment cannot give rise to a situation. And the question was whether it was within limitation or not. They said it can be decided in trial even otherwise. And therefore, there is another judgment in which they say Article 227 was approached by the parties in a case where there was an injunction passed by the trial court. The parties went to the High Court under Article 227, invoking the supervisory jurisdiction of the High Court. The Supreme Court in that case said, when there is a specific power and provision provided under Section 115 CPC, the High Court ought not to have entertained application under Article 227 in its supervisory jurisdiction, that is Virudhunagar Hindu Nadargal Paripalana, that is at 2019, 9 SCC 538, Justice Nariman and Justice Ram Subramanian. He said that the order was reversed, and then Supreme Court allowed the appeal, saying that the High Court could not have entertained this question under Article 227. Now, every wrong decision of the court cannot be said to be amenable to the revision, but it has to exercise the jurisdiction wrongly, the trial court, and the erroneous conclusion can be either of fact or of law. So it has to conform to the statute. When a power is given to be exercised under a statute, the court should exercise it only within the limits of the power which is given. So like that, we can say like a lower court, for example, has no jurisdiction, but it entertains the suit and decides it. Then that's an assumption of jurisdiction erroneously. Either it is pecuniary or territorial or even otherwise, subject matter wise also. Or it entertains an appeal, though an order which is not maintainable, and grants an injunction without considering a prima facie case. Or it allows withdrawal of a suit which is not falling under Order 23 Rule 1 also. Or failure to exercise jurisdiction. Like suppose you want to summon a witness whose affidavit is on record, the trial court says we can't now summon a witness for cross, then that is a failure. Failure to construe a decree by the executing court. Failure to give injunction on adhering to principles or referring to any rejection of plaint or whatever. So these are all with examples of failure to exercise. Then exercise of illegal or with material irregularity is what I told you about Major Khanna and Dilan. So that is a case where it was decided. In DLF housing also it was very elaborately dealt with in 1969 3 SCC 807 DLF housing versus Sarup Singh. So it gives a lot of examples without considering the evidence on record, decision on evidence not legally taken or otherwise inadmissible. These are all examples. So this is about revision. So this is one of the important provision. And as lawyers that we should advise our clients when a matter reaches us for advice or filing a case as a trial lawyer, or that we can do in appeals as well. These jurisdictions of appeal, revision, review are all very important. And if we get to know, this CPC is such a very beautiful, elaborate with all illustrations. CPC gives us all procedure, substantive as well as procedural aspects in the sections as well as orders. If we get to know and apply it, then it will be very useful for all the trial as well as appellate lawyers. So I think it is, I don't know whether we have crossed the time, Trivikram. We don't know whether there are some case law which I didn't want to elaborate because there is no time like now, because your time given will probably exceed if I have to go into each and every decision of the Supreme Court, which I had prepared a whole lot of list of cases for giving it to you. In case you say so, I will just pass it on, all the judgments, so that you can get an idea. You can pass it on to all the members as well. There are a lot of judgments about second appeal as well as revision also.
Certainly, ma'am. We are not running short of time. In fact, it's a very exhaustive topic. So if it requires, you may take 5 more minutes, ma'am. Absolutely no hesitation.
No, otherwise, if anybody has any query, then you can actually tell.
We will take up the Q&A session. So subsequent to that, perhaps I'll share the citation document.
Yeah, I'll email it to you. You can give it to them. No problem. Yes. Instead of my now giving you all the citations. So a lot of interesting cases are there. I will pass it on to you.
Please,
for those, yeah.
Indeed, thank you very much, ma'am, for a very informative session. Now, with your permission, we'll be moving on to the Q&A session. Akash, request you to unmute all the viewers. Can we have the first question, please? You may raise your hand. There's an option called as raise hand on Zoom app. So you may raise your hand. Can we have the first online question? Yes, sir. You are unmuted. Please go ahead. Gupta, sir, you may go ahead. You have been unmuted.
Okay.
I also see Mr. Bharat Babu, who is unmuted. You can hold on for a while. Yes, sir. Please go ahead.
Okay. Good evening, madam.
Good evening.
65 minutes non-stop. Mohana Raga, we have heard, madam.
I won't call it Mohana Raga.
Yes.
It's Mohana, it's fine, but I don't know whether everybody will approve of that.
Okay. Now let me come to the matter, madam. Now, Order 4120, Rule 27.
Yes.
We file an application to lead the additional evidence.
Yeah.
The first appellate court allows the application. Then the court finds it the additional evidence is required, and that whether the first appellate court can record the evidence, decide, or can it be remanded to settle that issue at the trial court.
That is given in Order 41, Rule 28 itself. That says either the first appellate court or it can do it itself, or it can remand it. Either way, it depends on what the nature of evidence is being looked into. So it is given in Order 41, Rule 28. If you see that, wherever additional evidence is allowed to be produced, the appellate court may either take such evidence or direct the court from whose decree the appeal is preferred, or any other subordinate court to take such evidence and to send it when taken to the appellate court. That is Rule 28, sir. Your query is answered.
Thank you, madam. Thank you.
Thank you, sir. Mr. Bharat Babu, I think you have been.
Yeah, good evening, ma'am.
Good evening.
It was a very informative session. Thank you very much.
Thank you.
Ma'am, my question is like bona fide purchaser is hit by the doctrine of pendant let. can he prefer an appeal if there is a delay under 227, Article 227?
227 is supervisory.
Yeah, because there is an inordinate delay, like around 1,250 days.
No, because you have no knowledge about the pendency of proceeding. If you show that you are a bona fide purchaser, you
Yeah.
can invoke this appellate provisions, the decree. You can challenge the decree in
Okay.
normal first appellate court with filing a condemnation of delay provision is there. 3A has been added to order 41. If you see order 41, there is a provision 3A which is added in 1977. Application for condemnation of delay is there. If you give adequate reasons showing that you are a bona fide purchaser and you are a transferee in title, anyway, transferee in title gets a right to proceed with the appeal provided you are a party. Now you are not a party and you have been cheated into purchasing this property. If you show that you have no idea and you have verified title and there is nothing in the record which showed that you would have anyway found it out. Like for example, if there is a registration of a mortgage, registration of a previous transaction, you would have checked it in the encumbrance. This you could not have checked in the encumbrance means then you won't, if there is a litigation, sometimes you won't know. Now only banks are also registering all the mortgages. Sometimes there are, encumbrances to the property, we purchase it without knowing. So unless, if you are able to show that you are a bona fide purchaser and with permission to file an appeal, you can move an appeal and you can move an application for condemnation of delay as well. Then the appellate court with your additional evidence, you can seek a remand also, in fact.
Thank you, ma'am. Akash, request you to unmute Mr. Kamalacharan. He has a question. And I also see two people raising their hands in the attendees list. Kindly promote them to the panel.
Good evening, ma'am. Thank you for that wonderful insight. Ma'am, I have a question. Under Section 89, a compromise decree is not appealable. But if that compromise decree affects or adversely affects the rights of another claimant of an immovable property, which is also the subject matter of another suit, and this compromise petition has been and decree has been passed by collusion between one of the parties to the existing suit and a third party, can the adversely affected party file a suit or or an appeal, or is it permissible for them to seek necessary relief in the existing suit itself?
No, 89 is not a compromise. 89 is a settlement outside the court.
Okay, I mean, but now the fact that a compromise decree has been passed and it adversely affects the party,
Then you have to go under order 23.
23.
Yeah, you have to go under order 23.
Okay, thank you.
Yeah.
Thank you, ma'am. Mr. Chandrasekhar has been raising his hand. Of course, Rangarajan sir, next would be your chance, sir. Mr. Chandrasekhar, you can unmute him, Akash.
Chandrasekhar, you can unmute yourself.
Good evening, madam.
Good evening.
Madam, in a suit for partition, one of the defendant dies and LR application came to be filed. And without allowing the LR application, the judgment has been passed against which an appeal is preferred under 41. But, madam, now the court can, without remanding the case for the trial court, can pass a judgment, madam?
No, you can't insist for a remand, but you can point out the error in the judgment that because you were not heard. You were not heard. What have you done about that? Have you filed an appeal?
Appeal is filed where I am for the plaintiff. What happened?
You are the defendant.
Madam, I am the plaintiff. What happened? Okay. The suit is decreed, but instead of granting the property, peculiarly the court has granted some monetary consideration without there being a prayer. Agreed by that, so I have preferred an appeal before the High Court, wherein I have made the respondent the LRs of the defendant in the appeal. Can the High Court decide without remanding the matter before the trial court?
Yes, they can. They can.
because judgment, technically the application is filed, but it is not allowed. The LRs of the defendant were not, one of the defendant's LRs were not brought on record. But in the appeal, I have made them as a respondent. Technically, the judgment is passed without the LRs of the deceased defendant. Can
But
the High Court?
for them to say that, no, that the judgment, it is for them to challenge that they were not heard when the judgment was passed. You are muted.
I think Mr. Chandrasekhar, you are muted. We are not able to hear you.
Hello.
Yes.
We are able to hear you.
Madam, can the High Court adjudicate the appeal without remanding the matter before the trial court?
Yeah, we cannot insist that a matter will have to be remanded. It is only for the High Court to see if it has all the material. That is 23A. If you see Order 41, Rule 23A, it says the High Court, if everything is before the High Court itself, it can definitely pass, either send the entire case, or if it feels it can decide it itself. 24 is where it can decide itself. 23A is even assuming all issues are there, even beyond the preliminary point also, the court can send it for retrial. If the defendant feels that he was not heard and they put forth the case to the High Court like that, the High Court can send it for retrial because they were not heard at all.
Thank you, madam. Out of purview, only one clarification, madam. Can a court, without seeking a prayer for monetary consideration in a suit for partition, instead of granting the share, can the court grant a monetary consideration, madam?
Can't do, because there are two things. One is in a partition suit, according to me, two decrees are there. One is a preliminary decree, another one is a final decree. In a preliminary decree, only the shares are assigned. You get what amount of shares you will get is what is delineated. After that, for appointment of commissioner, divisibility of property, whether money will have to be given or property will have to be given, is all for the final decree proceedings.
Under section 2 of
parties, but there are cases where parties consent. They give consent to do it in the preliminary decree level itself, that okay, I will take 10 lakhs, I don't want the property. That is sort of a compromise. Consensually, they pass that order. Otherwise, they don't pass. The similar issues are pending in the Supreme Court also, that you can't do that in a preliminary decree unless the party is willing to do that. The trial court will only say what is the quantum of your partition share. After that, what is to be done is decided in the final decree proceeding. Then commissioner is appointed. Thereafter, they decide whether it is impartible or it can be sold. Whatever will be decided, whether money will have to be appropriated, all that will be decided only in a final decree proceeding. So that's a good enough ground for challenge. Yeah.
Thank you, ma'am. Akash, you can unmute Rangarajan, sir. Next would be chance of Mr. Omkar Murthy.
Madam, good evening and vanakkam.
Vanakkam.
I am Rangarajan, therefore vanakkam to you.
Vanakkam, vanakkam. Very nice to see you.
Madam, I have two questions. One on review and another on revision.
Okay.
On the question of revenue, on the question of revenue, suppose there is a judgment rendered by Supreme Court in per curiam, either not noticing an express provision of law or in ignorance of a binding precedent. Would a review lie?
Yes.
A review lie, and the Supreme Court may.
It has done. It has done in cases.
Right.
There are several cases that has happened like that.
Excellent. My question on revision. Now, after amendment, there is rigor of provision 115. So, as advocates, we are abusing the process by resorting to Article 227 by approaching the High Court.
That's why Virudhunagar said, I told you now, Virudhunagar judgment says you cannot approach the High Court under 227 when you have the remedy under 115, which is the judgment which I just referred to you. I don't know whether you know.
Madam, can I complete my question?
No.
I understand, I appreciate. Now the problem with the advocates is the views are somewhat conflicting at the High Court level. In other words, At the threshold, if the Supreme Court were to say, henceforth under Article 227, under the garb of 227, what is revisable cannot be entertained.
What's your question?
My question is, should not the Supreme Court issue a general direction that high courts under Article 227 should not entertain any order against which a revision is prohibited, because under the garb of miscarriage of justice, to prevent abuse of process of court, we say kindly interfere and give justice. 115 is a bar, etc. Therefore, my humble view is, in an appropriate case, Supreme Court should put an end to this by issuing a direction to all the high courts. Kindly do not entertain such writ against an order of on the trial side under the CPC, because it frustrates section 115. That's
But
my
already in Virudunagar, whatever you have said, those concerns have been expressed, and the Supreme Court has said the availability of a remedy under CPC will deter the High Court not merely as a measure of self-imposed restriction, but as a matter of discipline and prudence from exercising its power of superintendence under the Constitution. They've said so in so many words. I think if this is all brought to the notice by lawyers to the High Court, suppose somebody is filing a 227, I am the respondent, I can very well bring the judgment to the High Court and say that this is what the Supreme Court has said. So kindly refrain from exercising this jurisdiction. So therefore, it is imperative on the lawyers also to keep on reading and keep on updating one's knowledge, so that we can go and tell the court concerned about this is a particular judgment. So this is already there. Please don't exercise. And they have alternate remedies. Isn't that correct?
Thank you, madam. Thank you, and Nandri.
Nandri.
Thank you, ma'am. Mr. Omkar Murthy, and subsequent to that, one last question by Mr. Abhirup. He had raised his hand. That would be the final question. Mr. Omkar Murthy, quickly you can pose your question.
Madam, namaste. Hello.
Yes.
You are audible, sir. Please go ahead.
Madam, whether an application under Article 41 Rule 27 is maintainable in second appeal under Section 100 before the High Court?
In extreme cases, it is appeal. It is available. It has been entertained. You have to only comply with the conditions. The Order 42 concerns second appeals.
Yes.
All procedures of Order 41 is also made applicable in Order 41, right?
Yes. Okay.
42 says all other procedures are applicable from Order 41.
Yes.
So you can use 27 and then put in your evidence and then say why it could not have been produced earlier. You have to only elaborate and prove that in spite of due diligence, this was not available to you. This could not have been produced. If you satisfy, in fact, at the Supreme Court level also, new grounds are raised, amendments are taken, additional evidence is given. In extreme circumstances, it depends from facts to facts of the case. So therefore, it is possible. You can do that.
Thank you, ma'am. One last question by Mr. Abhirup. Quickly, Akash, you can unmute Mr. Abhirup.
Hello, good evening, madam. Thank you so much for your very elaborate and excellent presentation, madam. I have a very quick question. Ma'am, I was just wondering, I was very confused by one particular provision of appeal under Order 43, that is an order passed for attachment before judgment under Order 38, Rule 5. Now, where the court does not give me an opportunity to furnish security, would that be considered as an order under Rule 5 or an order under Rule 6, ma'am? Because under Order 43, only Rule 6 is appealable. Rule 5 is not.
Rule 3 and this thing is appealable. Rule 2, 3 or 6 is appealable.
2, 3 or 6. But if I have not been given an opportunity to furnish security, then would that be an order under Rule 5, in which case I have no right to appeal? Or
Then
is that...
can be revisable. See, when you don't have appeal, or if it is a case decided, it should be. You know, in all other cases, I wanted to tell you, wherever there are interim orders passed in a trial, that is not 38, in a trial generally, whatever order which could not have been appealed during the interim period can be appealed when the final appeal is filed. That can be challenged, whatever interim orders are passed. That's one. Now you are telling me in a proceeding, in an attachment before judgment, you couldn't furnish security. Abiru? Abiru?
Ma'am, the court has not given me the opportunity itself to furnish security.
Then you may have to file an application for giving extension of time.
That was also filed. It has rejected it and again not given any opportunity. It has upheld its earlier order attaching the property.
So then you
Without
can
any.
speak under 6, no? So in case you are not able to show the reasons, then you will come under 6.
Okay.
You see 6.
Thank you, ma'am.
You see 6 where the defendant fails to show cause why he should not furnish security or fails to furnish within the time fixed, the court may order. So it will be under 6 only. So it will be brought under order 43.
Okay. Thank you so much, ma'am.
Not at all.
Thank you, ma'am. That was the last question for the day. On behalf of Advocates Association Bengaluru, I extend my sincere thanks to you, ma'am, for an extremely enriching presentation. Thank you so much.
Thanks a lot. Thanks for the opportunity. I also learned something. Thank you.
Thank you, ma'am. With your permission, we'll be logging off the session now. Thank you.
Thank you.